to the seminar on the Malawian presidential election decisions, a turning point for African democracy. Today, we are joined by participants across the world and most importantly from Malawi, given the focus of our discussions. Whilst the world was beset by a serious health crisis, we heard the news that the Supreme Court of Appeal in Malawi had upheld the previous decision of the Constitutional Court, annulling the result of the presidential elections held in May 2019. It did so by citing clear evidence of irregularities, which had been exhaustively looked at by the Constitutional Court, which threatened the integrity of the election, and its remedy involved requiring a fresh election to be held. It upheld that remedy, which will in fact take place next week. These decisions stand out for their courageous commitment to free and fair elections, and the refusal to accept the validity of a result where there was clear evidence of irregularities. They also stand out in contrast to many other decisions in the region, which effectively gave the imprimatur of respectability to an extremely flawed electoral process. The decisions also make a contribution to the jurisprudence on the judicial review of elections and raise the hope of a new era in African democracy where tampering with electoral processes will not be condoned by courts. We really have to get to that point. Since the decisions were released, SAIFAC has wanted to run a seminar on them. Given COVID-19, as I mentioned, there was very little attention in the international media and even in South Africa devoted to these decisions. Yet, as I've mentioned, they are highly significant and merit both academic and wider engagement. So, in my view, it should be a point of great pride to Malawians concerning the independence of their judiciary shown in this decision, and this should be applicable both to ruling party and opposition supporters. I must stress here that the seminar is an academic one, and it is not designed close on the heels of the election to be part of any political campaigning for one side or the other. We will seek to engage with a range of important questions flowing from these judgments, which will include considering, firstly, what is the political and constitutional context in which these decisions were made? What are the jurisprudentially noteworthy features of the Malawian judgments? How do they compare with some other judgments in the region? Why does Malawi seem to have achieved a higher level of judicial independence compared to neighboring countries? Are the judgments sufficiently proactive to preventing irregularities in the future? What regional and indeed perhaps global effects will the judgments have? And how can we use them to try and guarantee conditions for free and fair elections in the African context? And so to address this, I didn't introduce myself. I'm Professor David Bilchitz, the director of SAIFAC and a professor of law at the University of Johannesburg. And I'm delighted that we are able to bring together two leading expert panelists to address these questions. I'm only going to introduce them very briefly. So our panel consists of Professor Danwood Chirwa, who is the Dean of the Faculty of Law at the University of Cape Town, and is in fact himself a professor of law and an expert in a range of different areas. We've engaged on business and human rights and socioeconomic rights, and he is also a known commentator on the law in relation to Malawi. And Dr. Justice Mavedzenge, who is a legal advisor at the International Commission of Jurists in their African regional program. I'm delighted to welcome Justice, our first meeting online, and it's delightful to have you here. Justice is also an expert in law and has actually written two very interesting blogs analyzing the judgments from a legal point of view. So before I hand over to our panel, I would just like to thank SAIFAC staff, Naomi Hove, for doing all the work behind the scenes, getting everyone here and links to the seminar, as well as Ropafatso Maposa for their assistance with the seminar. I would also like to thank the Konrad Adenauer Foundation for joining us as a partner in the seminar. As I've mentioned before, they are a continual source of support for SAIFAC, and we really appreciate it. And I'm now going to call on Mr. Henning Soer, the resident representative of the Konrad Adenauer Stiftung in South Africa, to say a few brief opening words. Over to you, Henning.
Thank you so much, David, and welcome everyone all around the world, and especially our Malawian friends. Also a special welcome to our virtual panelists, if you let me name you like that. And of course, thanks to SAIFAC for setting up this event, which comes at the right date. As some of you of the participants maybe know, the Konrad Adenauer Foundation did or is doing several events on the elections in Malawi because it's a very interesting case for democracy in Africa. The Konrad Adenauer Foundation, as a German political foundation, is promoting democracy all across the continent and the world. And what we are trying is to enhance the political debate. We would like to create a forum where people can exchange their ideas and which is a space for free and fair discussion. So now to Malawi, as David pointed out, it's very interesting what is going on, because it does not only show the importance of free and fair elections and the vote, which has to be secret. It also shows that transparency is important, and of course the rule of law. It is amazing what happened in Malawi during the last month, and it could be an example to follow for many other countries. It is interesting that the judiciary is so independent because, as we know, I mean, that first-year student of political science or law knows that the separation of power is needed in order to develop democracy. But also for the international community, Malawi is teaching us some interesting lessons, because I shall remember here that we had international observer missions last year, which said that the elections were fine. And then afterwards, the judiciary said differently, or decided differently. So this also for, and being someone who's representing an organization from another country, this also gives things some food for thought for us about our approach. I think it is important to have as an objective that the promotion of democracy has to come from within a country. In the end, it's about the country people themselves. It's about the Malawians. It's in their responsibility how they would like to develop their country and what leaders they are going to choose. It's not about anyone from outside, and I just would like to mention this here once more. So again, I would like to thank David for setting up the event. Thanks to the whole SAIFAC staff, who's always so very much engaged and motivated and does that so brilliantly. And of course, thanks a lot to the participants. I will now mute myself and switch off my my video screen, but I will listen carefully to the discussion. Thank you very much.
Thank you so much, Henning. Much appreciated for those introductory words. And the Konrad Adenauer Foundation has also had a number of other events. I think they have a Malawi Day today, a focus on the political and now the legal and judicial side. And I think they have a later event as well. So it's fantastic that we're seeing a focus and we actually need to encourage more of that. So thank you very much, Henning, and again for the continued support. So just to explain to you how we're going to work the seminar, we're going to have two presentations today of about 20 minutes each from each of our panelists. Thereafter, we'll open for a number of questions. I also just want to mention we were contacted by an organization called iHub Online, a startup social media outlet that aims to create a platform for the discussion of issues of national importance in Malawi to stream the event. And they will be doing so after our event, so those in Malawi can view the discussion. We are also, as you will see, those on the Zoom, we are streaming live on Facebook. Some people will join us on Facebook and hope to make it available again online. So if you have people who couldn't make it at this time, they're welcome to view it later. And those on Facebook who responded, or if you just joined, you're welcome to send a question to the email address that you will be provided for on, or you were already provided with on the Facebook page link. So we request you please to keep yourself muted. And apart from the presenters, please keep off your videos to reduce the data consumption for those who wish to join. And the presenters also, if you want to switch it off while the other presenter's doing it, that's okay as well. If you wish to ask a question, you can pose a question in the chat section or simply put your name there and we'll try to enable you to ask that question orally. I will unmute you and you can put on your video for that purpose if you would like to. Okay, so that's the way we're going to proceed, and look forward to an exciting and informative discussion. And so without further ado, I'm going to hand over to Professor Danwood Chirwa to begin our discussion for his 20 minutes. Danwood, over to you. Let me just unmute you.
Thank you, David. Thank you very much for inviting me to this workshop. It's good to see that academics around the world are taking note of these two judgments. They are important, extremely important in the Malawian context, and perhaps also in the African context. Let me just point out that it's been an extraordinary week from last weekend to now in Malawi. As we were preparing for this presentation, things just blew out of proportion. As you may have seen, the government has attempted to remove the Chief Justice and one other judge of appeal, Justice Chirwa. And so we have seen an unprecedented fight back, which involved civil society, academics, many organizations within Africa and beyond. We received a lot of support from academics, emeritus as well, judges, retired especially, from many countries, for which we're very thankful. And I should apologize that we didn't reach out to all of you in that time when everything was helter-skelter, when we're trying to mobilize support, but we did reach many people and they did support, and we see that there's still continuing support in that regard. So the judges are not going anywhere, but it just underlines the importance of the discussion, what it takes for a court to nullify elections. It's not a small business, it is serious business, and it has repercussions personally for the judges concerned and for the country as a whole. There's a lot to say about these two judgments, but I won't touch on all the things that are there. I'll just briefly say what the judgments were about, what were the disputes. Then I'll highlight briefly what the court ruled and what has happened in terms of the orders that they were issued, but to reflect more importantly on what this judgment means, but also how was it possible for the courts in Malawi at this time to come to decisions like this. But also highlight at the end two major problems that the judgments have at least brought to light. So starting with the introduction to the case, the two cases, it's one case. The case dealt with the presidential elections in Malawi, which were held on 21 May 2019. In Malawi, the president is elected directly, while MPs compete in single-member districts. They can represent a party, but they can also represent themselves. Now, the outcome of the presidential election was that President Mutharika got 38.5% of the vote. Dr. Chakwera of the Malawi Congress Party got 35% of the vote. Vice President Chilima got 20% of the vote, which meant that almost 60% of the voters didn't support the president. And that's very significant in terms of the political context that emerged after the elections. So these election results were disputed by Vice President Chilima and Dr. Chikwera in separate petitions, which were later joined, practically focusing on the alteration of results using TPEX and other erasures and alterations, and tampering with electronic vote management system, the electronic vote management system. They also highlighted irregularities, non-compliance with electoral laws and violations of the Constitution. Now, these proceedings were commenced in the High Court, sitting as a constitutional court. It's important to highlight the fact that we don't have a High Court like in South Africa, a constitutional court in South Africa. The constitutional court is practically when the High Court is adjudicating constitutional issues and sitting in a panel of more than two. So there have to be at least 3 judges, and then it becomes a constitutional court, so-called. Now, normally the petitions like this are presented by way of evidence, affidavit evidence, but in this case, the lawyers asked for cross-examination, which meant that from the time the petitions were first filed, that is 31 May 2019, the decision of the High Court was only delivered on 3rd February. Hearing of evidence took more than about 80 days. So that duration is quite long to resolve political disputes of this sort. None of the commissioners participated in the proceedings. Only secretariat staff did, which means that the commission did not put itself make itself available to account for how it managed the elections. Now, the appeal was heard on 15 April 2020, and the decision was handed down on 8 May 2020. This is 1 year, almost 1 year after the elections were conducted. So it just highlights how long the dispute has gone. Now, both in the High Court and the Constitutional Court, the decisions were unanimous, quite rich in terms of the discussion of the evidence, but also the discussion of the law. And I'll highlight the findings of the court. Of course, the election was marred by vote tampering. The evidence was substantial, and the Electoral Commission failed to explain away the tampering. The court also held that there were other irregularities, including non-compliance with specific provisions of the electoral law and the express policies of the Electoral Commission. The vote tampering and irregularities were so substantial as to have an impact on the outcome of the election and to frustrate the political rights of Malawians. The court also held that even if the irregularities and vote tampering weren't enough to affect the outcome, the president was not duly elected because he did not obtain more than 50% plus 1 vote in that election. So this is a purely legal argument which has something to do with the interpretation of a section of the Constitution which deals with how a president can be declared, how a winner of the election is to be determined. So both these courts made these findings. The High Court concentrated more on the analysis of the evidence as it should. It's a court of first instance, and then the Supreme Court concentrated more on the legal justification of the findings. Now, as you know, the courts ordered the nullification of the presidential election and that fresh elections must take place within 150 days. Here, the Supreme Court thought that it should have been shorter, should have been maybe 2 months, but of course, this was the first time this had been done, and so the new elections are to be held next week on the 23rd of June. The court, the High Court had ordered Parliament to inquire into the competence of the commissioners. This has been done, and the Parliament made recommendations to the President. It found that the commissioners, all the commissioners, were incompetent, but the President ignored that. He didn't disband the commission. The terms of the commissioners expired by law, and he appointed a new commission, which includes 2 members who were found to be incompetent. The court also ordered legislative reforms to facilitate the fresh elections, but also the possibility of a runoff, which is very important in the case where there is no person, no contestant who has obtained more than 50% plus 1 vote. So the Parliament did take some measures. I don't think they were sufficient, just modest measures, and the President refused to sign them into law. Later on, there were some political machinations meant to repeal the 2 judgments, and that too failed. Now, I now get to the question of answering how was it that the Malawian courts were able to decide in this manner to overturn the elections. It's so hard, it's so difficult. It has been tried before in Malawi, but not successfully. I mean, there's a lot of debate in legal philosophy about how judges make decisions or how they should make decisions, with some saying that, oh, nothing else should matter. Judges should just make decisions based on facts, based on law, and that's it. But there are also those who argue that judges actually take into account factors such as political context, their own personal values and principles, public opinion, and all manner of factors which they don't spell out in their judgments, but sit within them as a reason about their decisions. I just want to highlight some of the contextual factors which could have played a role in thinking of the judges. Some, I think, much more prominently than others. The first is that the country, by the time of the elections and thereafter, has been undergoing worsening economic stagnation and disaffection, with very high unemployment rates, widespread unhappiness with the status quo. You could see that reflected in the other point that I'm going to suggest, the contextual one, that when the elections were declared, there was widespread unhappiness. The president had very little legitimacy, but also he failed to establish effective control over the affairs of the country. So he couldn't go to other regions of the country. He locked himself up somewhere in Blantyre, and when he moved out of his residence, he had almost like a garrison of soldiers around him, and that in a way also showed that he wasn't actually in control. Somebody else was in control, and everybody was, that somebody else was just, everybody was doing whatever they wanted. There was regular outbreaks of violence. The police had lost trust. They couldn't control the situation, and the security, the internal security, was taken up by the army. And in this case, this was seen also in the way the judges themselves were protected. It was something quite striking to see, in that the judges were wearing bullet protection vests, whatever they call it, and they were being transported into these convoys by the military in a way that showed that there is no effective control over the affairs of the country by the ruling party. Thirdly, there has been deteriorating standards in electoral administration and management in Malawi, which has resulted in a corresponding deterioration in governance and constitutionalism. So judges were aware of this, that from 1993, 94, 99, and all those elections, the standards were just keeping going worse and worse and worse and worse. The fourth contextual factor is the composition of the courts. I think this played a major role. The Constitutional Court, as I said, is when the High Court is sitting more than with at least 3 judges adjudicating a constitutional matter. This is not in the Constitution. This came up by way of a High Court, the Court Amendment Act, and it came about from not noble intentions. It was, in fact, to try to neutralize single judges from nullifying elections like this, or from quashing decisions of the executive. And somewhere around 99 or thereabouts, 2000, former President Bakili Muluzi didn't like the fact that judges had so much power to quash decisions of the executive. So he created this law which said that when the High Court is sitting in a constitutional matter, it must do so in a panel of at least 3 judges. Now, that has had huge consequences. It was meant to tame the judiciary, but in retrospect, with hindsight, and the evidence we have seen, it has significantly bolstered the High Court in the sense that when judges sit in panels of 3, it is very difficult to impeach the decision. In this particular case, it was decided by the judiciary to empanel 5 judges. And so you had 5 judges sitting, which reduced possibilities of corruption. So that went out very well. Then the Supreme Court as well sat in a panel of 7. Previously, they used to sit in a panel of 3, but 2 years ago, the Supreme Court adopted new rules which allowed it to sit as a whole panel, and in this case, there were 7 judges who sat in this case. I think this had a big impact because corruption is rampant in Malawi, and as you may know, you may have heard, there were even efforts at the High Court level to buy out some of the judges. The biggest impact within the Malawian context of this judgment is the interpretation of the meaning of the majority of the electorate in Section 80 of the Constitution. This is the section that says, in order for a president, a contestant who becomes the president must at least collect a majority of votes. And in this case, the High Court said majority of the electorate here means not a plurality of votes, as the Supreme Court had decided in 1999. And that was significant for the High Court, for the Constitutional Court to say that, given that there was a decision of the Supreme Court that had said that majority of the electorate means simple majority, it just means more than other people's votes. And that 1999 decision almost set the gains that Malawi had made in 93 and 94 back by many years, because from that time, the legitimacy of the presidency has been going down and down and down and down. So this was an important reversal. It is the Constitutional Court, the Supreme Court gave much more legal justification to this, and I think they are right. But the political consequence of this holding is that we now have a chance to address problems of regionalism, which are a problem in Malawi. We have a chance that political parties will try to become more national, at least to speak to the whole nation, and maybe a chance to have more coalitions as we go forward. The second is the clarification of the constitutional legal duties of commissioners. As I've said, this was something of a problem in terms of trying to say what standard of care does the Electoral Commission have in conducting elections. It seemed that the standards were falling and falling and falling, and the courts have clarified this. I think the judgment also within the Malawian context, where the ethics for lawyers, respect for ethics, it's almost non-existent. The judgment tries to speak to the question of how lawyers should practice the law, avoiding conflict of interest, but also just professionalism. I think the biggest problems the judgment raises, for Malawi at least, is the problem of electoral dispute resolution. It can't be taking 8 months, 1 year to resolve this. It has to be done within a short time, probably a month. And so trying to come up with a specific special mechanism for electoral dispute resolution mechanism would be very useful. There is something of this sort in Kenya, there's something of this sort in Uganda and other African countries. Probably in Kenya, in Uganda and Zimbabwe as well. And that is something that is huge, that needs to be resolved. The second is the problem of transitional measures. So in this case, the election was nullified on 3rd February, and we still have a president who is behaving as if they have legitimacy. They have a cabinet. They're making all manner of decisions, including trying to remove judges from the court. I think that shouldn't happen. There should be clear transitional measures when something like that happens, so that the contestants don't use the resources of the state to their own benefit. One last problem that has been raised by these judgments, there are many, I just am choosing here, is the institution of election observation and monitoring. Internally, party monitoring systems are non-existent, and the problem we have is partly because of insufficient party monitoring systems. All political parties, the major ones, did not have their own results. They haven't produced them up to now. So that's something that has needed to be improved. But the biggest problem is the institution of international monitoring system, observation system, as was highlighted by our colleague from the Konrad Adenauer Foundation. In this case, we saw that yesterday or a day before, former President Olusegun Obasanjo speak to this question. In the Malawian case, we had the institution of international observation working against local actors trying to hold the Electoral Commission accountable. And this highlighted the tension between the international and the local in terms of accountability. So there is accountability to the international and accountability locally, and sometimes that undermines local democracies. The EU in particular did something so outrageous, and perhaps that hasn't been done before. They decided to release their report just when the High Court judges had ended the proceedings, and they had now retired to consider the judgment. That was the time when the EU, in its wisdom, decided to release its report. And there was an outcry, internal outcry, to delay the release of that report. The EU took long to accept not to release the report. I don't know whether they finally did release the report, because they did cancel it after the judgment. Probably they haven't released the report because it is embarrassing to them. But the point is that what we have seen here in operation is to highlight the problem of electoral observation, this international system. It is a system that answers to no rules. It is not regulated by any treaty. There is no accountability framework from it. People just come in into a country, and after elections, they write these reports, normally that bear no relation to what takes place. So one hopes that these cases, these two judgments, will lead to the international institutions, the UN and other institutions, to rethink the institution of election observation. With these remarks, I will stop, and thank you very much once again. I'm looking forward to the discussion.
Thank you so much, Danwood, for that very interesting analysis. I can see already we have some comments in the chat already. People are engaging with what you've said and providing a sort of analysis and contextual factors around around these decisions, which are fascinating, as well as some of the really important consequences more generally. So without further ado, I'm going to hand over to Dr. Justice Mavedzenge, and Justice is going to address some of the perhaps particularly legally interesting issues that arise from the actual changes in law, perhaps we can say, in relation to the judgments. So without further ado, Justice, I'm just asking you to unmute now. Justice?
Okay, can you hear me?
Great, we can hear you. Thank you very much. Over to you.
Fantastic. So I would like to thank Professor Chirwa, Danwood, for helping to set the context, particularly for a lot of the other things that I am going to say. He has done a great job in taking away the burden from me of dealing with some of the contextual nuances coming out of Malawi. Thank you very much, Prof. Thanks, David, for inviting me to come and speak on this platform. And thanks to the participants. And yes, I am a legal advisor at the International Commission of Jurists, where my work centers around working with judges, lawyers, civil society, and academics to promote the independence of judges in Africa. I'm also an academic with an interest in constitutional law, socioeconomic rights, elections, and human rights in general. And it's good that today we are talking about elections. So I am going to be brief on quite complicated things that I'm going to be saying in this presentation. But so that you can also go ahead and verify, and maybe also read around and get a more in-depth discussion on some of the things that I will say. Let me just preface this presentation with about 5 references. So a lot of the things that I'm going to say today, I have said them in an article titled "Taking Stock of the Zimbabwean 2018 Elections and Evaluating Prospects for Democratic, Free and Fair Elections in the Future." It's with the Southern Africa Public Law. There is also another paper titled "Constitutional Courts as Key Sites of Struggles for Human Rights Protection in Autocratic Jurisdictions, a critical assessment of the Constitutional Court of Zimbabwe's human rights jurisprudence in its first 6 years." It's in the African Human Rights Law Journal. It does touch on a lot of things that I am going to talk about today. I also want to draw your attention to 2 blog pieces, which I did. One is titled "The 5 Episodes of Violence Which Undermine Prospects for Democratic Elections in the Future in Zimbabwe." It's in the Democracy in Africa on the Democracy in Africa platform. Then on Malawi, there is a blog piece I did for Opinion Jurists titled "A Breath of Fresh Air as the Supreme Court of Malawi Breaks Rank with its own precedents and peers in the region." So those pieces deal in greater detail with a lot of views that I'm going to share with you today. So it would be great if you can check them out and contest some of the observations that I make there. And of course, I think I should acknowledge Professor Jonathan Moyo's work titled "Excelgate: How Zimbabwe's 2018 Presidential Election Was Stolen." It's a publication, I think, released last year in 2019. It makes quite controversial claims. I don't agree with a lot of the things that are said in there, but I agree with some of the things. And they corroborate some of the views that I'm going to make today. Now, what is the structure of my presentation? I've divided my presentation today to be in 3 parts. So the first part is I will deal with the key concepts. Right? I prefer to outline the concepts so that I don't have to go back to them again in the course of the presentation. After dealing with the concepts, the key concepts, I'm going to answer the question: what did the Supreme Court, what did the Constitutional Court and the Supreme Court of Malawi do differently when compared to the Constitutional Court of Zimbabwe and the Supreme Court of Zambia? I focus on Zimbabwe and Zambia because those are the 2 countries where, prior to the Malawi decision, the courts had dealt with the merits of an election petition. In other cases, in other jurisdictions, the cases were knocked off on technicality or procedural technicality. I will conclude my presentation by attempting to develop further what Danwood has dealt with in his presentation, where I want to try and postulate on why was the Malawi Constitutional Court and the Supreme Court able to do things differently. So when I'm saying Constitutional Court and Supreme Court, for those that are not familiar with the Malawian jurisdiction, I think I refer you to what Danwood has already said. He has explained the difference between the Constitutional Court and the Supreme Court. But what I wish to do in my presentation is to acknowledge that, as Danwood did actually, that the decision to overturn the elections in the way that I'm going to describe and theorize today was first made by the Constitutional Court. Then it was upheld by the Supreme Court. So sometimes I think in discussions, not on this platform, but in other platforms, I've noticed that people talk about the Supreme Court's decision, forgetting that the Supreme Court was simply upholding what the Constitutional Court had said. But of course, the Supreme Court did a great job in terms of bringing in or explaining further some of the legal positions which already had been advanced by the Constitutional Court. Now let's deal with the key concepts, and then we fly off, because when we are it's just that we don't have flights anymore. But if you are flying, the flight attendants start by dealing with security procedures and all those other things in order to prepare you for the flight. So in order to prepare you for the presentation, let me deal with these concepts. So election petitions is one of the key concepts that we need to engage with. What is it? It is a mechanism to trigger judicial review of an election or its results in order to evaluate compliance with the electoral law. I think it's very important to keep that at the back of our mind for you to then be able to understand the arguments that I will be making in my presentation. The second key concept is presumption of validity of election results. Both in SADC and globally, the courts have taken a general position that election results must be presumed to be valid, and courts must be slow to interfere with the results. The reasons for this position are well captured in the judgment of, for instance, the Tanzanian High Court in the 1970 case of Madundo versus Mweshemi and Attorney General Mwanza, where the court said, open court. An election petition is a more serious matter and has wider implications than an ordinary civil suit. What is involved is not merely the right of the petitioner to a fair election, but the right of the voters to non-interference with their already cast votes. Close quote. So that is Madundo versus Mweshemwi, the decision of the Tanzanian High Court. I think it's very important to flag out these very key decisions coming out of the African jurisprudence. David and I had a conversation about this prior to this seminar, about the importance of flagging out the important aspects coming out of the African jurisprudence. The third key concept that I want to flag is the legal tests for nullifying election results. And I think this is very important for us to master, because I'm going to come back to this concept a lot in my presentation. So globally, there are at least 2 legal tests which are applied in order for a court of law to decide whether to uphold or to invalidate results of a presidential election. Because in many jurisdictions, they make a differentiation between presidential election and other elections. First is the qualitative test, which is applied when irregularities are alleged. According to this test, the results of a presidential election can be overturned if the petitioner can prove that the election was marred by irregularities that amount to substantial non-compliance with the electoral law. When that test is applied, there is no need for a petitioner to prove that the irregularities had an impact on the election results themselves. The second test is what is called the quantitative test, which requires that where irregularities are alleged, it must be proved that these irregularities substantially distorted or affected the results of the election. So in other words, it is not enough to prove that the election was marred with serious violations of the electoral law. The petitioner must, in addition and by necessity, prove that the violations had a major quantitative impact on the results of the election. The last key concept is standard of proof. So this refers to the threshold of evidence which a petitioner is required to meet in order to satisfy the court that the petitioner has made a valid claim. Now, ladies and gentlemen, brothers and sisters, those are the key concepts that I will be engaging with in the rest of my presentation. Now, I think we can take off, because we are now, I think I've now made clear what I mean by these terms when I use them later on in my presentation. Let's deal with this question. What did the Constitutional Court and the Supreme Court do differently when compared to the Constitutional Court of Zimbabwe and the Supreme Court of Zambia? So in my view, the Malawi Supreme Court and Constitutional Court in the Peter Mtaruka versus Chakwera decision, or which I will refer to as the presidential election petition of 2019, what it did differently is that pertaining to the legal test for deciding whether to nullify or uphold the election and its results. Both courts said, particularly the Supreme Court said, the qualitative and quantitative tests are applicable depending on the facts. And then the court went on to apply the qualitative test because of the facts which Danwood has thoroughly dealt with. In doing so, the court departed from the trend in the region. And I will show you. Let's go to Zambia. In the 2001 general election petition brought before the Supreme Court by Anderson Kampela Mazoka. So the title of the case is, and the citation is Anderson Kampela Mazoka versus Levy Patrick Mwanawasa. So the Supreme Court accepted evidence proving that there had been violations of the electoral rules, which included the improper use of the State Intelligence Unit to interfere with the election management. However, the Zambian Apex Court insisted that proving these violations was not enough to nullify the election results. The court held that the petitioners should have proved electoral malpractices and violations of the electoral laws in at least a majority of the constituencies in order to show that there was a substantially quantitative impact on the result. So you can clearly see that the Anderson Kampela decision, Mazoka decision, is applying a quantitative test. Similarly, in the 2018 petition in Zimbabwe between Nelson Chamisa and Emmerson Mnangagwa, the Constitutional Court applied a similar test. So that's the first. That's the first thing, the first difference that you see the Malawian court on where irregularities have been proven. It chooses to apply a totally different test, which is in this case is the qualitative test. And obviously it's a positive thing. I explain why I think it's a positive thing in the article that I highlighted at the beginning of my presentation, and I'm happy to engage in the plenary and say why it is a positive thing. But the second other thing regarding to legal tests, which I think the Malawi court did differently, is to clarify that both the qualitative and the quantitative tests are applicable depending on the facts of the case. It is this position is different from what we saw coming out of Zimbabwe in Nelson Chamisa versus Emmerson Mnangagwa, where the court said the only test to be applied is the quantitative test. So in other words, the Malawian court is telling us that both tests can be applied, whereas the Zimbabwean court is telling us that only the quantitative approach should be applied. Now, the second other thing which the Malawian Supreme Court and the Constitutional Court did different was to clarify the position regarding the standard of proof. So in recent decisions, both Zambia and Malawi, both Zambia and Zimbabwe, as I will show later on, recent decisions on presidential election results petitions, the courts in SADC countries have not been clear on their position regarding the appropriate standard of proof to be applied in cases where the petitioner alleges that irregularities of non-criminal nature were committed in an election. Obviously, if the claim is that if the irregularities are of a criminal nature, the normal standard of proof applicable in criminal cases applies. But if it is of non-criminal nature, the jurisprudence in the region prior to the Malawi decision over the 2019 petition, the decisions in the region were unclear. Now, let me show you why I say they were unclear. In Zimbabwe, in the case of Nelson Chamisa versus Mnangagwa, the court simply said, open court. It is for the applicant to prove to the satisfaction, and I think I should read this slowly. It is for the applicant to prove to the satisfaction of the court that the election was conducted in a manner which fell substantially below the statutory requirements of a valid election, and that the result was materially affected, warranting a nullification of the result. So what the court said is the applicant must prove to the satisfaction of the court. However, the court did not indicate the standard of proof required for the court to be satisfied. It didn't tell us what is the applicable standard of proof which a petitioner must discharge in order to satisfy the court that they would have made a valid claim. So that's the Zimbabwean case. Let's go to Zambia. Similarly, the Zambian Supreme Court in Anderson Kampela, Mazoka versus Levi Mwanawasa also said the court must be satisfied that the irregularities distorted the results. The court said the petitioner must submit credible evidence to satisfy the court that the result of the election was distorted. So what the court tells us there in the Supreme Court decision in Zambia is that the petitioner must submit credible evidence in order for the court to be satisfied. But what is the standard of proof? Credible evidence, yes, but what is the standard of proof? That question is left open in that particular case. Let me go back. Let me show you something about Malawi as well, which I think the Supreme Court in the 2019 election petition deals with as well. So in Malawi, there was once a petition which came before the Supreme Court, the previous bench, in a case called Gondwe and another versus Kotami Nyahara, where the Supreme Court insisted that the petitioner must provide credible evidence to prove that the irregularities affected the election results. So in other words, that court borrowed from the Mazoka decision in Zambia, or took rather a similar position to the Mazoka decision in Zambia. But what it didn't tell us is what is the standard of proof. So that question was open until the Constitutional Court and the Supreme Court handed down its decision in Malawi over the 2019 presidential election case. As a departure from its own precedents and the trend in the region, both the Malawi Constitutional Court and the Supreme Court in the 2018 election petition said the petitioner must prove prima facie that irregularities or violations of a serious nature happen, and the respondent, who in most cases the election management body, must rebut the evidence on a balance of probabilities. So what we see the Malawi Supreme Court and Constitutional Court doing is to perfect our jurisprudence in the region by plugging in the holes that were there. Where the question of standard of proof was open, the Malawi Supreme Court has come in and proposed an answer. Of course, the answer is binding in Malawi. It is persuasive in the region, in the jurisdictions of the region. Now, let me, again, typical of a flight, you know, there will always be an announcement in a flight to say we are now descending. So can you fasten your seatbelts and put away your tray tables? So in the same fashion, I am encouraging you now to fasten your seatbelt, because we are now landing. And I think we are landing with some hard questions that I would like us to engage. But I will make some propositions. And those hard questions arise in the context of this question. So what could have made it possible for the Constitutional Court and the Supreme Court of Malawi to be so robust? And again, like I mentioned at the beginning of my presentation, Danwood has done a very good job in trying to start that conversation by flagging some of the nuances within the Malawi contextual realities. Now, I would like to compare those things, those realities, with some realities in Zimbabwe. I won't reference Zambia for lack of time. So I will try and look at why did the Constitutional Court in Zimbabwe, why was the Constitutional Court in Zimbabwe not as robust as what we saw in the Malawi judgment? And for the avoidance of doubt, for me, being robust does not necessarily mean that the court must overturn the election results. Being robust means engaging with the concepts of law without fear or favor, and then arriving at a decision which is based on the evidence presented before the court and based on the way the court engages with the relevant legal principles and concepts. And I think the Malawi, both Constitutional Court and Supreme Court, did very well in terms of engaging with the concepts, did very well in terms of engaging with the evidence. And I believe that the decision that it reached is in line with the evidence that was before the court and is in line with the applicable legal principles and concepts. But being robust is rather the engagement as opposed to the nature of the verdict. Now, there are 4 things that I think made the Malawi court able to be more robust than the Zimbabwean court.
Justice,
One of those,
in terms of timing, if you can just summarize those very quickly so we can bring in some of the questions. Great.
Yes, I will do that, David. So the first is judicial culture. And I think Danwood has already spoken about that. I think the Malawi court, the Malawian judiciary has a totally different culture compared to the Zimbabwean judiciary. I think the Zimbabwean judiciary tends to overly defer to the executive, especially on election matters. I will refer you to 3 cases that you can read on. Mavedzenge versus Minister of Justice, Gabriel Shumba versus Minister of Justice, Mateta versus Zimbabwe Electoral Commission. You will see what I'm talking about. The second point is the political conditions themselves, which also have a bearing on the judicial culture. I think the court in Malawi, as at the time of the decision, was operating under a completely different set of political conditions compared to Zimbabwe. Remember, the 2018 election in Zimbabwe was preceded by a coup. And so basically the court was determining this petition in an environment which has been shaped by a military coup. And so questions are abound as to what extent are judges, questions arise as to what extent are judges free to make a robust, fearless decisions in that kind of environment. Third is the quality of opposition. I think the opposition in Malawi was better organized in terms of election monitoring and evidence gathering. I think the same cannot be said about Zimbabwe. Fair and fine, the judges were probably not as robust as they were supposed to be, but I also think that the opposition was unable to bring some of the most direct evidence which was required. Fourth and last is the quality of the case itself. I think the Malawi petition was based on more direct evidence, e.g. copies of TPEX election returns, copies of fake unsigned election returns. The Zimbabwean case, in some parts, was based on conjecture rather than hard evidence. Then also relating to the quality of the case, the arguments made in the Malawian case were more specific, succinct, whereas I think the arguments made in the Zimbabwean court, some of them were superficial. They were couched in high verbosity, but really in terms of substance, they were quite lacking. And Jonathan Moyo does very well in terms of showing how and why some of those arguments were superficial. I will end here for now, David, and I am happy to respond to questions that may have been triggered by what I have said. Ladies and gentlemen, thank you for listening to me.
Thanks very much, Justice. Thanks for engaging with, I think perhaps many people here are interested also political context, but there are some actually legally important developments in those judgments, and you very succinctly and clearly outline some of those rather complex issues about the standard of proof, burdens of proof, etc., that are required, and those are actually very significant for these kinds of petitions. So, and their success. So we have already had quite a chat going on, which is excellent, and that's why I wanted to leave a few minutes for questions. We do want to finish relatively sharply at past the hours. So one question is about the Kenyan election, how this judgment differed. So one other major comparator is that the Kenyan Supreme Court nullified an election, and there was a very quick election, and it was ill prepared, and there was a similar result, and it wasn't like any of the conditions were really properly addressed. And so I suppose that's the concern here as well. Is there any difference here that leads one to have more faith that, for example, the structural conditions around the Electoral Commission have changed, and this will be a better a better election will be run from a procedural point of view? I know, Justice, you had addressed Zambia and Zimbabwe. Do you want to say something about Kenya? And then maybe Danwood, do you want to also engage with whether you think the orders were sufficiently strong to address the institutional problems? Justice. You muted. I think you muted yourself. Let's just keep ourselves unmuted. Let me just, I'm going to unmute you. I'll ask you to unmute. You can unmute yourself now.
Thank you, David. Look, I think the Kenya decision, the latest one, I think was quite similar to the Malawi decision in as far as the test is concerned. Although I think the Malawi decision was more elaborate and clarified that the appropriate test should be dictated by the facts, and went deeper in terms of explaining the kind of facts which would warrant the application of each of those tests. But I think Danwood has already made this point that it is not enough to simply say there must be a rerun of the presidential election, or the presidential election must be held afresh, because the challenge is that the incumbent may then take the opportunity of the transitional period to manipulate electoral institutions, right? We saw that happening in Kenya, and we see it happening right now in Malawi. So but then there is a limit towards, to the limit to the extent to which the court can go in terms of ordering institutional changes. The legal framework does not allow for anything beyond, for the court to say anything beyond what it said. So maybe what is necessary is for those of us in the academia, lawyers and other jurists, to then try and think around how the legal framework can be reformed to allow for institutional reforms, which will allow the kind of transition which Danwood spoke about.
Okay, thank you, Justice. Let me go to Danwood. Danwood, what are your thoughts on this? Do you think the court should have gone further in its orders to address the institutional incapacity problems and try and prevent a rerun of the problems?
Thanks. I think Justice has addressed the question in many parts. I think the first bit, just to comment that the difference between the Malawian decision and the Kenyan one is that the Kenyan decision placed more emphasis on the principles. So they looked at where fundamental principles violated in the conduct of the election, and if they were, we notify. The Malawian court looked at both that aspect as well as the evidential aspect. So on the basis of the evidence, they also found that the election didn't meet the cut. On the question of whether the courts could have done more, I think they did go very far, pushing the limits of judicial deference, and I think they did the right thing to call upon Parliament to do the next step. What they have done so far, at least as far as I know it, by saying that the Constitution means this in terms of who to declare, how to determine who the president-elect is, the reforms that have to take place after that are for the legislature, because there's just too much lawmaking that needs to be done. I don't think the Parliament did a good job in the few reforms that they tried to put to the president. That is not what really is needed. There's far much more that needs to be done. And after the elections, we hope that will be taken up. As to the voter turnout, I'm not in Malawi at the moment, but from what I can see, people are not giving any respect at all to COVID. It's like it doesn't exist, or they don't feel it. And so we expect that the voter turnout will be high, at least for the most part of the country.
So the question of free and fair elections obviously raises various questions about the monitoring mechanisms. Obviously here we see a failure of an electoral commission. And one of the attempts, and Danwood, you mentioned this, which has elicited a lot of discussion, is around election observers. Will election observers, I imagine that there may be less missions this time because of COVID, but will there be election observers at this time? And Danwood, you seem to suggest that you felt it was good that people could run their own elections, but isn't this an important, you raised the problem that there aren't really proper standards to govern election monitoring, but isn't it an important independent check that there are at least a variety of other delegations looking over what happens in the elections? Danwood. Danwood, I think is let me unmute. There we go. You should be able to.
Thank you. You unmuted me now. Yes, that's an important question for us, because I don't think that we should not have international observers. We should. But it seems that they are pissed off. The EU said they are not interested in the election. You know, that's what they said. We don't know whether the Commonwealth mission is going to come, whether SADC is going to come. At least from an African, from the AU, Obasanjo's statement is strong on this point, that Africa should not let Malawi down again. We need the election observers, the international ones. They were useful in 1994. 1993 especially. In this case, in fact, we needed international assistance in terms of skills to assist the Electoral Commission, which was found to be incapable of running elections. In fact, now they only appointed a commission for 2 weeks to do its job in 2 weeks. So we really needed international support, but this is known within the diplomatic world. They're not interested. And so if we can pull this off ourselves, it will make a huge statement that we can do this. We don't need the support that we have always been claiming that we need. It's a good thing if it works, but if it doesn't work, maybe not so good. Thanks.
Right, and I perhaps Justice, I don't want you to have to go into it in a lot of detail, but you didn't give your reasons as to why the qualitative test was preferable really to the quantitative test that you explained around nullifications of elections. Do you want to perhaps briefly just give your reasons on that? I know it's a complicated question, you've written about it, but perhaps some people will be interested to know why is it important, as I understand it, the question is, why is it important that if there are, let's say, a certain number of irregularities, which wouldn't necessarily have tipped the result, but affect the integrity of the election, that nevertheless a court will overturn the result? Perhaps you can have a word on that. Okay, Justice, you may have muted yourself again, so let me just unmute you there. Yeah, go for it.
Okay, thanks, David. Certainly, I mean, in the context of SADC, we have something called SADC principles and guidelines on the conduct of democratic elections, which a whole lot of these SADC member countries have ratified. It's not a treaty, but these are principles and guidelines that are supposed to give effect to the SADC treaty itself. So if you read it in the context of SADC, the SADC constitutive treaty, you will see that it has some degree of force. A fair election in terms of the SADC principles, and even in terms of the African Charter, on African Charter, a fair election is an election that is held in accordance with established rules, right? Now, you will see that in the context of Zimbabwe, in Malawi, you see that there are constitutional rules or constitutional principles which guide elections, right? So we certainly can't say when an election is conducted in violation of those constitutional rules, we certainly can't say that election cannot be nullified until the petitioner is able to show us that the results were also affected. So why in the first place put in the constitution those principles? In the case of Zimbabwe, section 155 has got about 5-6 principles which should guide elections, the conduct of elections. So my point is the qualitative test allows us to focus, allows election management bodies and the judiciaries, when they do review, to focus on compliance with the law rather than focusing on the outcome of the election. Because the outcome of the election can also be a product of violations of the law. So rather we should focus more on the compliance issues. But of course, lastly, David, the election is a huge logistical exercise. It's rare that there can be an election without irregularities. What should matter is what is the nature of those irregularities. If the nature of the irregularities affect constitutional principles, affect basic principles of democratic elections, then the qualitative test is the appropriate test to apply. But if they don't affect, the basic principles or the constitutional principles, the court can be willing to overlook those if there is no effect on the results.
Right. Thank you very much, Justice. I think it's very powerful, and this is a very important issue. And actually, courts have hidden behind those kinds of legal tests. I certainly think a lot of the Zimbabwean decision was, let me say, use harsh language here, but was extremely unconvincing, and so from a legal point of view. And so, yes, now we actually have some really interesting questions which have just come through. So I wanted to try and get to them. We've got one about the interim period before the elections. It does, in a way, relate to what I asked before, but the argument says that there's been several abuses of power by the president, taking advantage of the unprecedented environment created by the ruling. This is a problem, of course, because you don't want to have a vacuum, but at the same time, should what do you do in the interim period? Does the court doesn't want to govern, but how does it create a situation where there isn't interference in the preparations for the new elections and the independence of the judiciary? Danwood, I may need to also unmute you again. Let's see, there we go.
David, do you mean the interim arrangements between the decision to nullify?
Yes, the constitutional court. Yeah, the constitutional court's decision and then the actual rerun. Yeah.
Okay. So firstly, the biggest thing for us is that there's nothing that talks about the vacuum. In other words, the only provision that closely talks about these transition amendment arrangements in the Constitution is the one that says the president shall serve the term of 5 years and until the new president is appointed. I think that means up to 23 or 21 May, when the elections, the normal elections happen. But after that, then there's a vacuum. So there's a gap there. And the Constitution also talks about conflict of interest. It's a very important principle in the Constitution that the president shall not be in a position, exercise power in a position, shall not abuse the power, especially is bound by the principle of no conflict of interest. And that is in the Constitution. But what we see and what we have seen after the nullification of the elections, that the president has been appointing commissioners, he has been refusing to sign bills, he's been trying to dismiss judges and trying to appoint. That is after the legitimate period within which for which he was elected has expired. And so that suggests to me that we do actually have to have a caretaker kind of president. Normally this is done by discussion between the political parties and say, okay, let's create a legislative framework for this period. They did not do this. And so I have no doubt that this is needed. But more importantly, it's to deal with if no one succeeds to reach the 50% plus one bar. How long should the next the rerun be? Okay, and on what basis should it be conducted? So there's a whole range of reforms that are needed there. But I think that with the way we know how power is used, there has to be someone neutral, whether it is a Speaker of Parliament or somebody independent, defined under defined circumstances to do it. Thanks.
Okay, so we are coming to the end of our time. So I wanted to give you, there is a question about the 50% plus one. I think you just briefly mentioned that, Danwood, and that also the question is it actually applicable to this election? So perhaps in your closing statement, you can address it. And I want to hand over to you both to just give about 2 minutes closing statement on what you think the significance of these decisions are for the future of African democracy. What are the likely effects regionally and perhaps globally? So I know that's a tall task in such a short time. So without further ado, let's give Justice his chance, and then Danwood, you can give a closing comment. Justice, please go on. I'm unmuting you.
Thank you. For me, I think the Malawi decision is an interesting and a very positive decision, which I expect to have a persuasive influence across the region. You would know that in the region, a lot of our constitutions allow courts to borrow from comparative jurisdictions by way of applying foreign law. So the Malawi decision would be regarded as foreign law in other jurisdictions. But foreign law, and I think this is an issue that needs to be further investigated, David. But foreign law, in my view, plays a peculiar, a significant role in the adjudication of election petitions, precisely because most of these jurisdictions, particularly in SADC, do not have enough in their local jurisprudence on election petitions. Why? Because most of the time these petitions are knocked off on procedural technicality. Mm-hmm. And also the phenomenon of presidential election petition is a new one, started in the 2000s and so forth. So there isn't much in the local jurisprudence for the courts to use. So in many cases, when you read even the Kenyan decisions, the Ugandan decisions, even the Malawi decision, when you read it, you will see that there's a lot of engagement with foreign law. So it is a good thing that we have an African court, an African jurisprudence that is thoroughly engaged with concepts that are applicable in election petition adjudication. And in my view, we should expect to see a lot of reference to the Malawi decision in the petitions to come in future in all these jurisdictions. That's the first one. The second and last one is that I think when election management bodies begin to run elections, they will have at their mind what the Malawian court said, particularly about the qualitative test, to say an election which does not comply with the basic and fundamental principles, rules laid down in the Constitution can't be regarded as an election, irregardless of the impact of those of that non-compliance on the results. And I think it's something that is going to stay on the mind of election management bodies. But it's also something that is going to stay on the mind of civil society bodies and those who are responsible for gathering election rigging evidence. So that's for me the influence that we are going to see, likely going to see coming out of the Malawi court. The influence will be in the judgments, but the influence will also be in the practice, in my view. Thank you.
Thank you so much, Justice. I think that's very strong and powerful closing statement. And to hand over to Danwood to address these questions.
David, to the question whether the 50% plus one vote is already applicable, it is. And my closing remark is just to say that nullifying elections is a big deal. It has huge consequences. And the only way in which a court could have the courage to do so is when there's competitive politics. They know that a regime could go out of power. If there is no that incentive that things could change, then courts will find a reason, even when there is evidence, to stay away from that, because the consequences are huge. We've seen in Kenya, we are seeing it in Malawi, that the executive hits back. And when it does, it compromises the judiciary entirely. They try to capture it. So these kinds of decisions can only take place in places, in countries, in African countries where politics is competitive. There's a chance that the other guys, the other parties can get to power. And so there's an incentive of the leadership to govern according to law. Without that, that's not possible. Thanks.
Thank you very much, Danwood. I think it's a good place to end, and I think an important one that of the critical nature of judicial independence, and we assert that very, very strongly. That is only it's a wonderful thing when you see a court exercising its judicial independence. It's not because it favors any one party. It's about assessing the evidence, assessing it in an objective way, and coming up with conclusions. In these cases, there were clear irregularities, which any one fair-minded person would see as hampering the legitimacy of the result. And so what you see here is the courts not turning an eye, as a blind eye, as some of the other courts have done, sadly, in the region, and actually, as a result, brought the institution of the judiciary into disrepute, but actually, I think, enhancing judicial legitimacy. And I think critical is going to be the importance of respecting that, developing that culture of respect across African democracies. And I think very importantly, in what Justice said is, I think there's some wonderful statements in the early part of the Supreme Court of Appeal judgment about the power of democracy and its importance in the African context, and why only government that is legitimately elected, right, which is truly a reflection of the people's desires, will be a legitimate government. And I think these judgments have actually taken that important step, created really excellent jurisprudence on which other courts can draw in upholding these kinds of principles. And for that, we must be grateful and thank the judges of Malawi, and we look forward to engaging with these judgments. There are, of course, matters of dispute and discussion to be had further about them. And I hope in this seminar, all those who with us find this, have found it really interesting, intriguing. We've had wonderful, I thank our panelists for really wonderful contributions, and you'll be motivated to go and read these decisions and also follow what's going to happen in Malawi. We really wish the Malawian people the best for the coming election. We hope they are indeed free and fair, and that the result will reflect the wishes of the people. And we hope that, again, this will be a landmark for constitutionalism in the region. So with that, I just want to thank, again, our panelists. Thank you for participating. And